Allow me to thank Judge Tomke for these very kind words of introduction, far too flattering. I would also like to thank him and his colleagues, Judge Benuna and Judge Salam, for their attendance. These three judges are in our midst. I take this as a sign of their friendship. It is a great honor and great pleasure for me to see them here. Ladies and gentlemen, my topic today is the flow of multilateralism. On the 21st of March, 2019, President Donald Trump wrote on his Twitter feed, and I quote, "It's time for the US to fully recognize Israel's sovereignty over the Golan Heights." End of quote. Thereby openly breaching international law, and in particular the United Nations Security Council Resolutions 242 and 338. Shortly thereafter, the US ambassador declared that Israel had the right to control certain parts of the West Bank. Because they emanate from the world's first superpower, these statements are not just like any other unilateral declaration. They do not just define the conduct henceforth to be adopted by their author. They go further than that. They strike a body blow to the international order itself. And such a stance can also have the effect of a pull factor. We saw, for example, that the decision to relocate the United States Embassy to Jerusalem inspired other states to do likewise, in breach of UN Security Council and General Assembly resolutions, as well as the Vienna Convention on Diplomatic Relations, according to the application lodged by the State of Palestine before the International Court of Justice. These examples, on the back of many others, are naturally a cause for concern for the world order, particularly so as they are happening against a backdrop of global uncertainty. Uncertainty which takes on a number of forms in different places: the rise of populism, the return of anti-Semitism, the climate emergency, the terrorist threat, cybersecurity, trafficking, challenges to democracy, and challenges to what we believed were societal acquired rights. On a more general note, we can feel that we have moved on or are in the process of moving on from the key principles of European and Western philosophy, because the center of global gravity is shifting. We have to acknowledge this. I understand Mr. Védrine will be exploring this subject with you tomorrow, much better than I ever could, thanks to his exceptional first-hand experience of the international stage, and therefore I shall not labour this particular point. The title of my inaugural lecture begins with 1919 to 2019. I think we're all familiar with the Treaty of Versailles, signed with Germany on 28 June 1919, following 6 months of negotiations at the Paris Conference. What's perhaps less known is that there were a number of other treaties signed with Germany's allies, and that together they make up what is known as the Versailles Peace Treaty. Owing to the political climate at the time, 1919 really was a major turning point in terms of the way in which the world was organized. Its implications exceeded many of the precise and often technical questions that had been broached during negotiations. The international intellectual environment was imbued with the notion of peace through law, following on from the conferences organized in The Hague in 1899 and 1907. The American president, President Wilson, set out his political and moral views in his famous 14 points presented in January 1980, in other words, before the end of the war. The personality of the negotiators was also to play an important role in this process. I'm afraid I don't have enough time to introduce you to the British statesman Lloyd George or to the Frenchman Georges Clemenceau, but I will just say a few words about the American president, Wilson, who was a pivotal figure in the area of multilateralism. The League of Nations was in fact the last of his 14 points entitled For Just and Moral Relations. I think that says it all. The title says it all. Wilson, who was a former president of Princeton University, was an intellectual. There have been intellectual presidents of the United States of America. He was a historian. He was a political scientist of great renown. His political and moral ideas were inspired by his Presbyterian faith, itself rooted in Calvinism. Owing to this, Wilson set great store by the notion of a pact, as understood in the organization of the Calvinist community. Wilson's 14 points may therefore be read as a pact that would organize the world with the United States of America chosen, so to speak, to establish the new governing order. Please note that this is a recurrent position. President George Bush, Sr., by way of an example, also defined a new world order after the 1991 Gulf War. This new world order was to be based on a bedrock of American values. So, in 1919, a new international order was established with the creation of the League of Nations, which was the first political international organization seeking to regulate multilateralism. And in a way, the League of Nations also symbolized multilateralism. The pact, which was unanimously adopted on 28 April 1919, would then be transposed into each of the treaties making up the Versailles Peace Treaty, accounting for the first 26 articles in each case. Incidentally, we should not forget to mention the creation of the International Labour Organization, which was established in accordance with Part 13 of the Treaty of Versailles, and whose centenary we also celebrate this year. Allow me now to explain what I mean by the term flow of multilateralism over the course of the last century. Flow is the movement of the sea when the tide rises. The flow is normally followed by an ebb. So, I could arguably have entitled this lecture The Ebb and Flow of Multilateralism. But I didn't. And I didn't because I do not believe in an inevitable ebb, even though much is made at the moment of the end of multilateralism, the end of globalization, excessively so in my view. It stands to reason that globalization needs to be revisited and reined in. However, whatever form it takes, it will continue to exist, and it will continue to rely on multilateral instruments whose content might differ, but to which it will inevitably be intricately linked. As for President Trump's railing against multilateralism itself, it could actually be his style that is baffling. Because, after all, this is nothing new. Every now and again, the United States of America express mixed feelings about multilateralism. There is always a Monroe Doctrine background to all of this in the minds of the Americans. I should also perhaps remind you that following the Senate's objections, the United States of America did not end up joining the League of Nations, even though the League of Nations was Wilson's brainchild. Furthermore, the USA have sometimes bypassed rules of international law. I'm referring here, for instance, to President Clinton and Kosovo in 1999, or to President Bush, Jr., and the 2003 Gulf War. In fact, his term of office was a fairly constant illustration of this point, and if you're prepared to overlook the Hollywood tropes, I could recommend to you the film Vice, which is not without merit. President Trump's attachment to an avowed unilateralism, President Trump's opposition to multilateralism, go hand in hand with a certain defiance towards international organizations which are the most obvious embodiment of multilateralism in this day and age. The US are leaving or threatening to leave some of them. Some of these international organizations or bodies that are spin-offs of these organizations. UNESCO, nothing new under the sun there because that's already happened in the past. The UNRWA, which provides services to Palestinian refugees. The Human Rights Council. Alternatively, they will try to put a spanner in the works of other international organizations such as the WTO, where the reappointment of judges to the appellate body is being held up by the USA. They're also walking away from the Paris Climate Agreement, the Pact on Migration, the Trans-Pacific Partnership on Free Trade. There's also the attitude towards Iran, including the procrastination that we've seen recently. This is deeply worrying, because what is at stake here is world peace. Moreover, it's difficult to fathom, since what is ultimately involved here is reneging on the 2015 Vienna Treaty, according to which Iran undertook not to build nor to possess nuclear weapons, and then trying to obtain the very same result through bilateral negotiations and sanctions. Not necessarily very successful as an approach. We saw yesterday, in fact, that Iran has now returned to its uranium enrichment program. And today, or was it last night, President Trump announced that new sanctions would be meted out. So we're now entering into a spiral, a game, a little bit like the wheel in a hamster's cage going round and round. Mr. Trump is essentially applying a principle that he described in a publication that he authored, or at least signed off on, in 1987, in which he explains a businessman's negotiation tactic. He says, first, be violent, flex your muscles, and then, once your opponent has been knocked out, offer them a deal. I'm not sure that the art of diplomacy necessarily follows exactly the same rules. Finally, what should one make of the unprecedented declaration made by John Bolton regarding the International Criminal Court, where he says, and I quote, "We will ban its judges and prosecutors from entering the US, we will sanction their funds in the US financial system, and we will prosecute them in the US criminal system," end of quote. The list could go on, and every item on the list would constitute bad news. And yet, I don't think I'm being blissfully optimistic when I say that we need to analyze and transcend these situations. We need to raise our gaze, look beyond the here and now, perhaps even look back towards the more distant horizon of the long march of history. In this auditorium, I've often relied on a metaphor, that of a ratchet. The ratchet is a little piece of metal that prevents a star wheel from going into reverse. It goes forward, ever forwards. I've often used this metaphor to make the following point, namely that despite these little hiccups, or the fact that occasionally we do seem to go into reverse, still the wheel continues to turn, and overall progress continues to be made, and the world keeps moving forward. Now, admittedly, the existence of international law has not stopped some states from resorting to force. However, such force has not legitimized the acquisition of territories, contrary to what may have been the case a century ago. Admittedly, human rights breaches still happen, but many of them are prosecuted nowadays. Admittedly, the International Criminal Court is going through a rough patch, but although legitimate criticisms may have been voiced, it should also be duly noted that these courts have not been slacking. In fact, as I speak, right now, the International Criminal Court is handing down a ruling in the Bosco Ntaganda case, the commander of the Patriotic Forces for the Liberation of Congo, who is charged with 13 war crimes. I would also like to quote an idea from a recent Harvard lecture given by Judge Salam, where the justice shared some reflections on international law in changing times. I understand that it will be published soon in the Harvard Law Review. I would invite you to read this article once it's published. It contains a lot of substantive points, particularly on international justice. And I just wanted to make the following comment. A few years ago, as pointed out by Justice Salam, people only used to talk about Nuremberg or Tokyo. The idea of establishing an international criminal court seemed a little far-fetched. The International Law Commission had admittedly been working on the subject for about 40 years, but progress was so frustratingly slow that people thought that it was a pipe dream. Now, the track record of specialized tribunals for Yugoslavia and Rwanda is far from insignificant, even though many criminals have managed to avoid sanctions, but the very existence of an international criminal court, be it specialized or general, has ushered in an era where we put an end to the abuse of the principles of sovereignty and immunity. There are, I believe, many other examples that could be adduced in support of this idea of global progress, the advancement of the high tide prevailing over fleeting low tides. And this is thanks to the multilateral actions undertaken by states. In that sense, multilateralism blends in with international law. It is its means of expression, which we'll look at first, it is its means of action, second, and it is its institution, finally. So first, multilateralism as a means of expression. Oddly enough, the legal technique of the multilateral treaty, because it is a treaty, it actually arrived quite late on the scene. It's a form of facilitation, essentially consisting in recording in one single text, signed by all, what used to appear in different bilateral texts, which were repetitive in nature. It's commonly agreed that it wasn't until 1856, the Treaty of Paris, after the Crimean War, that the first genuine multilateral treaty was drawn up. Since then, the technique has developed. It has since, in fact, become the norm for all acts or instruments adopted at large international conferences or drawn up by international organizations. And in that sense, multilateralism is both an instrument and content. And signing up to multilateralism means embracing a certain vision of the international order. It is a political act in the most noble sense of the term, an act in the general interest. Then, as an expression of policy, if you'll forgive the truism, multilateralism should be contrasted with unilateralism and bilateralism. Compared to the former, it is positively disposed towards a consensus society, a society of agreement. Compared to the latter, it shows both quantitative and qualitative differences. Quantitatively, in terms of the number of stakeholders involved, and, more importantly, qualitatively, in terms of the types of interactions it encourages. This is, in fact, something that diplomats, in their everyday practice, know perfectly well. They know the difference between what they call the bilateral and the multilateral, and diplomats are happy to express a preference for one or the other. They can actually perceive the two as two different lines of business. To be an ambassador posted to a country or being a special representative seconded to an international organization are not the same thing. In 1648, when the foundations of modern international law were being laid, the new principles that emerged pointed towards the possibility of multilateralism, even though the term was not used at the time. Multilateralism, in fact, only entered the stage more than 2 centuries later, but the seed had been sown. In particular, through the much-needed principle of equality. In fact, they even decided at the time to open up more doorways to the meeting room so that everybody could enter the room simultaneously to avoid turn-taking. It was about equality for all. Equality and its corollary sovereignty. Hence the expression sovereign equality, which was incorporated 3 centuries later into Article 2, subparagraph 1 of the UN Charter. The history of international relations is punctuated by big congresses and conferences which in their own way gave expression to multilateralism, although it did still not go by that name. nor did it have its legal forms. But nevertheless, these congresses and conferences did often constitute milestones, turning points in the organization of interstate relations. And in that regard, 1919 was genuinely a turning point, since the principles outlined by Wilson and the founding of the League of Nations signified the culmination of a movement that finally came to a conclusion with the two conferences in The Hague, 1899-1907. It's the League of Nations that takes on from there, because of course the third conference could not be held because of the war. Multilateralism made people aware of the interdependence between states and peoples. This does not mean uniformity. It does not mean surrendering one's own characteristics, one's own culture. It simply means acting in concert. And on that point, let me say that it is a serious mistake to believe in protectionism in a world where we all depend on everyone else. Now, granted, in an electoral campaign, a slogan such as America First might score a few points. In an electoral campaign, it scores points. But it is also a very short-sighted option in a world that is now designed to promote trade and cooperation for the greater benefit of all. Multilateralism also presupposes a culture and a mindset that are open. The big conferences organized by the United Nations on major societal issues have shown that, whatever the outcome, some have failed, some have succeeded, some have half succeeded. Whatever the outcome, they've shown that it's important to gather different cultures and visions around the table to try to define the most appropriate ways forward. These conferences were convened not solely but particularly in the 1970s at various intervals. They looked at the environment, habitat, population, children, women, human rights, and so on and so forth. And that is, I think, how one should understand global diplomacy. Global diplomacy is designed to equip us for the demands of tomorrow's world, equip us for its pitfalls, its new technologies, its increasing interconnectedness. Multilateralism is also an expression of the general interest. It is a fact that the major challenges that we face in this world cannot be usefully resolved without a multilateral framework. Neither a unilateral act, no matter how powerful the state in question, nor bilateral agreements, whose scope by definition is limited, neither can hope to resolve issues such as global warming, or terrorism, or cybersecurity, for a very obvious reason, namely that these phenomena do not stop at borders. Judge Salam, incidentally, explains this very well in his article. They don't stop at borders. By definition, they concern us all. For the environment, we know this. We've known it since the old arbitration case in the Canada-USA trace smelter dispute. Or, if you think back to Chernobyl, the Canard Enchaîné, a satirical magazine in France, claimed that a senior official had said, "Don't worry, the cloud will stop at the border between Germany and France." It turns out, in fact, that the senior official had never actually said this, and he sued the newspaper for defamation and won his case. But still, people believed the story and were much tickled by the supposed statement on clouds stopping at borders. So it may be a truism to say this, but if there is to be a solution to global warming, to the extinction of living species, to migratory flows, etc., then this solution can only come from the international community. I put the international community in inverted commas. I'm sure you'll understand why, but it will come from that community, and it will come in the form of general multilateral actions. The Paris Agreements of 12 December 2015 were a serious wake-up call. A wake-up call in terms of our awareness of the general interest. Now, many states gave voice to their passion. Unfortunately, much of that zeal has since waned. There's also the stubborn position adopted by Donald Trump, which caused a lot of harm. once again, he inspired copycats. It's quite interesting to note that at the last Osaka G20 summit, President Bolsonaro of Brazil finally decided not to step back from the Paris agreements. He abandoned that tack and he turned instead towards Mercosur, the Mercosur agreement between Mercosur and the European Union, and a kind of deal was struck. Had there not been this negotiation, then yes, Brazil would have followed the example set by the United States of America, and Mr. Bolsonaro would have followed in the footsteps of Mr. Trump. Over and beyond the specific example of the environment, the general interest also feeds into the general international law by introducing objective rules. I know you know this. You know all about mandatory rules which transcend the will of states, thereby expressing a form of binding normativity with universally held values. Everyone can identify with these fundamental standards. These are the erga omnes obligations, or the jus cogens standards, the Rolls-Royce. I'm sure you no doubt remember the late Ian Brownlee and his reference to the Rolls-Royce which had finally left the garage, which could now cruise down the avenues of multilateralism. Great principles of international humanitarian law, such as the ones referred to by the Court in its 2004 opinion on the construction of the wall, also find their roots in multilateralism. They constitute the architectural framework of our edifice of international law, whose foundations are anchored in shared values, thus implemented. So, multilateralism is also a form of action. Naturally, it would be impossible for me to list all the aspects of this particular part of my presentation in this lecture, because it would mean going through all forms of international relations with a fine-tooth comb, alliances, collective security, Chapter 7 of the Charter, legitimate self-defense, etc. I shall therefore refrain from addressing these substantive matters. Allow me instead to home in on two aspects which deal more with the methods and the techniques of multilateral action, some aspects of which may not be common knowledge. First, conference meetings, and second, the decision-making procedure. A few words on conference meetings. Over the course of the years, and over successive major conferences organized by the UN, we have seen the emergence of what is known as parliamentary diplomacy. Parliamentary diplomacy has turned multilateral negotiations into a rather sui generis procedure, markedly different to bilateral negotiations in many ways. For instance, the adoption of conference rules, which are inspired by General Assembly rules, the constitution of a bureau with the president of the conference at its helm, the drafting of rules of procedure. These are all elements that are reminiscent of so-called parliamentary law as found in domestic constitutional legislation. Seeking to draw up some kind of exhaustive list would be overambitious. Allow me therefore to simply mention a few procedural idiosyncrasies that are often overlooked. One such aspect is the choice of venue for diplomatic conferences, a complex decision made particularly difficult because you're talking about a multilateral rather than bilateral environment. It's difficult because there are more potential political problems depending on where you choose your venue. And in addition to that, you have practical constraints. If you're bringing together almost 200 states, each state may be represented by a delegation of several dozens of delegates. You can't just go anywhere. There are only a very few cities that can actually accommodate such a conference with the venues for the conference and the hotel capacity to go with it. So your choices are limited. Furthermore, you may wish to meet within premises that are vested with symbolic meeting, or deliberately not. I'll take the example of the Hague conferences, where this is foregrounded. The conferences in The Hague, well, Tsar Nicholas II was of course the cousin of Queen Wilhelmina, and that was no doubt helpful. It's actually quite interesting to read the circular published by Count Morafiev, sent out by him on behalf of the Tsar to the different European leaders who at the time were in fact world leaders. I would remind you that the Latin Americans were not present in 1899, only in 1907. The circular said, we must go to The Hague. The Hague is nice, it's a peaceful city, it's calm, you're far away from any conflict, it's very serene, a perfect venue to talk about peace. And of course, you're here in The Hague. You'll see in the evening how quiet and calm a city The Hague is. Just imagine what The Hague might have been like at the end of the 19th century. It was extremely calm. And so it was agreed that speaking about peace in this particular location would be a good idea. We're all aware of the fact that symbols are influential in the world of politics. They have a bearing. They can point you towards a certain outcome, or they can help gloss over certain stumbling blocks. Then, decision-making procedures, voting arrangements are also a hallmark of multilateralism. At the League of Nations, it was unanimity that was the rule, because in the name of sovereignty, each state had the power to call matters to a halt. At the United Nations, it is the two-thirds majority rule that applies to important matters, as set out in Article 18 of the Charter. Other matters may be decided by a simple majority. The two-thirds majority may also be found in Article 9 of the Vienna Convention on the Law of Treaties. This majority rule is clearly reminiscent of domestic legislative procedures. One may then wonder about the quality of negotiations depending on the decision-making rules in place. For instance, at the time of the League of Nations, some would argue that unanimity had a flip side, namely the risk of blockage, but, nevertheless, unanimity allowed the text to be more thoroughly negotiated, since the adoption required overcome the very last objection to the text. But you could also argue the exact opposite. For a text to be adopted by unanimity, conference would need to move from one concession to the next in order to try to please everyone, and ultimately conference would produce a text that was relatively vague or built on constructive ambiguities in order to be palatable to all. And, of course, there are political considerations to bear in mind. The British were very much in favour of a majority rule because all the dominions could vote along with the British. The French had no dominions, so they preferred a unanimity rule. There was therefore a disagreement there between France and the UK within the Entente Cordiale. For matters of the highest importance, the United Nations have finally decided to opt for qualified majority voting, and this is flanked by a reservations mechanism which is designed to promote multilateralism. States are thus able to sign up to an instrument despite their objections to some of its provisions, against which they will enter reservations, against which in turn other states may object. I'm sure you're familiar with that mechanism, but this leads to the establishment of an increasingly complex treaty system with guarantees, with prohibited reservations, for instance, as one of those guarantees. Then there's also the non-objection procedure, the so-called consensus procedure. That's another part of this equation. I won't particularly dwell on this. If I had more time, I would talk about its history. I would tell you how this actually emerged in the first place, this concept of a consensus in 1964. It was because the Soviet Union, and indeed France, didn't want to pay their dues to the United Nations. What I'd like to say, however, to conclude on this point, is that whatever the decision-making process, it doesn't really have any bearing on the legal value of the instruments adopted. For instance, a General Assembly resolution is still but a recommendation, whether it's adopted by majority, unanimity, or consensus. Final point now, multilateralism as an institution, and I'll use the example of the International Court of Justice. I'm using the term institution as understood by the Italian Santo Romano. At the beginning of the last century, he spoke of the institution as a legal order, and that's also my understanding of the term. It might seem somewhat strange to refer to the International Court of Justice in this area. Usually, when you talk about the institutionalization of multilateralism, you refer to international organizations, because that is where you see multilateralism being institutionalized. But I would prefer to talk about the court, because I think it's interesting to sometimes think outside the box. The 19th century has been described as the century of congresses and conferences, and the multilateralism of the day was therefore set up in a world that was completely lacking in organic structures. The 20th century, however, is different. The 20th century is the century of international organizations. I'm sure you've heard that before, with an emerging international order that will be rolled out with the help of international organizations, and that is modern multilateralism. The International Court of Justice is not the usual reference used to illustrate multilateralism, and yet, in my opinion, the ICJ does play an important role in our legal vision and in the implementation of multilateralism. And I think that this can be tackled from two angles. I'll briefly talk you through them. First of all, jurisdiction, and secondly, the effect of judgments. First, on jurisdiction. At this moment in time, there is a remarkable tendency to bring matters to court. Most often, this is done on the basis of a jurisdiction clause. Referrals by prior specific agreement are a much rarer occurrence. I think this is a good sign. I think it indicates that states have taken care to include such clauses in the treaties they adhere to. Or it also proves that they subscribe to the so-called Fernandez Clause, accepting compulsory jurisdiction in accordance with Article 36, paragraph 2 of the statute, although it should be noted that this is not as successful an approach as it was at the time of the Permanent Court. Still, I should point out that by the 1st of January 2018, 73 states had signed up to that clause. Not bad at all. Then, of course, you need to look carefully at the content of the reservations that states may have attached to their acceptance of jurisdiction. And you have to bear in mind that the court's jurisdiction will be interpreted on the basis of the lowest common denominator. This is all within the limits of reciprocity, and I'm sure you're familiar with the case law of the Norwegian loans. It should also be noted, with regret, that only one of the permanent members of the UN Security Council, namely the United Kingdom, still stands by that optional clause on compulsory jurisdiction. Indeed, France withdrew its declaration accepting compulsory jurisdiction of the court after the 1974 ruling in the nuclear tests case, while denying any kind of causal link. They denied that they were withdrawing because they were upset with the court. It was just a coincidence of dates. And then the USA openly withdrew their acceptance following the ruling against them in the military and paramilitary activities in and against Nicaragua in 1986. And as you know, China and Russia never subscribed to the clause in the first place. So yes, admittedly, a referral by prior specific agreement, which is much less used, as I pointed out earlier, does provide an advantage in that, as a matter of principle, they avoid procedural delays which arise from challenges to jurisdiction of the court or to the admissibility of the request. Two states have agreed to go before the court, so they generally do, whereas a state that is brought before the court following an application based on a jurisdiction clause will often seek to avoid proceedings by challenging jurisdiction or admissibility. Still, whatever the drawbacks of the delays in dispute settlement, I still believe that a generalized trend towards signing up to an optional clause on compulsory settlement is actually a win-win solution. For one thing, it allows for the settlement of a whole host of legal disputes, whole categories, with, of course, exceptions. Still, this can be done on the basis of the law applied by the highest global judicial institution. And I'm sure you will agree that this is the best way forward. Furthermore, it seems to me that this is a win-win solution also because of the macro legal terms, if I may use that term. What I mean by that is that anything that facilitates access to the International Court of Justice is beneficial to the international community as a whole, since it strengthens the ensuing legal architecture. In domestic law, the rule of law would be inconceivable without generalized access to a court, and similarly, the establishment of an international law-based community, to which we aspire, requires the same approach. We can therefore understand the crucial role that may be played by the court that serves the general interest and goes well beyond the interest served to the parties to the case. And from that point of view, Article 36, paragraph 2 of the statute is of great importance. A few final words now on the effects of decisions. I acknowledge that the Court's mission is to decide in accordance with the law such disputes as are submitted to it, Article 38 of the statute, and that consequently its decisions have no binding force except between the parties and in respect of that particular case, in accordance with Article 59 of the statute, as I'm sure you know. In its case law, the Court needs to meet requirements of consistency and continuity, since consistency and continuity provide the legal certainty that any litigant would expect, and it also cements the trust shown by states towards the Court. So without even applying the rule of precedence or stare decisis, which are concepts that have been transposed into international law, the Court still guarantees this continuity for the benefit of states who stand to gain from what one might call a foreseeability principle. Foreseeability not so much in terms of the solution that may be arrived at because you don't know, but rather foreseeability in terms of the content of applicable law. And this foreseeability requirement is particularly important when there may be some uncertainty regarding the law, and it is absolutely necessary to retain the trust of states. This form of continuity is not only a reference to what has already been subject to a judgment, it's also a projection into the future. The Court, by its very nature, is building law. It's not its mission, but de facto, by its nature, that is what it is doing. And by doing so, it fulfills a mission that goes well beyond the settlement of the specific dispute before it. Whilst, of course, the Court needs to guard itself against any kinds of accusations of judicial activism. The ICJ has to be very cautious when it comes to identifying new legal norms. There have been a few occasional bold steps. You could look, for example, at the advisory opinion of 1996 on the legality of the threat or use of nuclear weapons, which makes for some interesting reading in this regard. Over and beyond the substantive considerations which may be viewed as milestones in its lawmaking activities, the Court can sometimes also find itself in a bit of a bind between its undeniable general and global role as a lawmaker and then its primary and specific task of settling a specific case. It therefore has to be cautious on both fronts, looking at what has already been judged in the past, ensuring consistency, but also looking towards what might one day be subject to a judgment in a comparable case, bearing in mind that whatever is decided today may prove problematic in future. Ladies and gentlemen, my conclusion can be summed up in one sentence. Look around you. Multilateralism is you. Thank you.